Our next speaker is Ms. Christine Chanet, former chairperson of the UN Human Rights Council's fact-finding mission on Israeli settlements. Ms. Chanet is also a member of the UN Human Rights Committee, having served twice as its chairperson, and a member of the UN Committee Against Torture. We are honored to have you with us, Madame. You have the floor.
Merci, Madame. C'est moi qui...
Thank you. Well, it's my honor to be here among you all. I would like to thank the organizers and the Committee on the Exercise of the Inalienable Rights of the Palestinian People, the Arab League, the Secretary General, Ambassador El Arabi, who I know very well, who I met in Geneva in another life, and the organization of the Islamic Conference, as well as the State of Belgium, who have allowed us to meet here today. In March 2012, not so long ago, the Human Rights Council, as you said, created an international, independent, fact-finding mission, which was tasked with considering the facts concerning the impacts of settlements in the occupied Palestinian territory, including East Jerusalem. This mission was comprised of 3 women: Unity Dow, a judge in the Supreme Court of Botswana; Asma Jihangi, a lawyer from Pakistan; and me. I was the chair of the commission. In 2013, the mission submitted its report to the Council, and the Council approved the report almost unanimously. Only one vote was missing, and I'm sure you can imagine which one. The report established a number of facts and put forward conclusions and recommendations. In order to be able to do this, the mission conducted many interviews. It held an open session in Amman. And it heard from speakers from NGOs, religious representatives, the ICRC, diplomatic representatives, and more than 60 written contributions were received from Mr. Dulgar, the special rapporteurs. And I think that this was one of the reasons why the mission was not widely criticized. Indeed, it received a great deal of information from Israeli civil society, lawyers, journalists, NGOs, Israeli NGOs, and so all of this information was used to corroborate the facts already reported by representatives of the Palestinian Authority and Palestinian NGOs. There was a great deal shared between the two analyses, in which I heard also yesterday. Now, this was, of course, 2012 and 2013. That's still fairly recent. The mission did not simply establish the facts, but since it was made up of lawyers, those lawyers could not refrain from their natural tendency to place these facts in a legal context. And so that's what I propose that we do, since we're discussing today the legal nature of settlements and violations committed. Starting with the legal nature of the settlements themselves. We've mentioned this a great deal, but we need to go back to basics. In the eyes of the international community, Palestinian territory is an occupied territory. I'm sure that seems clear today because it stems from all of the relevant resolutions that we heard about yesterday, from the Security Council, reiterated by the General Assembly. And this was also recalled in the advisory opinion of the International Court of Justice from July 2004. But in fact, the court is only recalling customary international law and the 1907 Hague Regulations, under which a territory is considered occupied when it is actually placed under the authority of the hostile army and the occupation extends to the territory where such authority has been established and can be extended. This is paragraph 78 of the opinion. So this gives us the initial legal framework of what the occupied territory is, and with everything that implies, and the court draws conclusions from this, namely that the status of occupied territory imposes obligations on the occupying power, including that of being subject to the requirements of the 1949 Geneva Conventions and also the international human rights covenants on civil and political rights and economic, social, and cultural rights. And this is in paragraph 101 of the opinion and then paragraphs 111 to 114. Now, the court also mentions Article 49 of the Fourth Geneva Convention, which says that the occupying power shall not deport or transfer its own civilian population into an occupied territory. After having recalled this text, which it does specifically, the ICJ concludes that settlements established by Israel in the occupied Palestinian territory, including East Jerusalem, were done so in breach of international law, and this is paragraph 120 of the opinion. So this is not an occupation, and this distinction was made yesterday, but rather colonization, which is denounced by the court. So the fact-finding mission shared this analysis, and indeed went further than the court, because the court delivered its advisory opinion in 2004, and it could not envisage the nature of war crimes as defined under the Rome Statute creating the International Criminal Court. The mission, however, in 2012 did do this, and it considered that this situation could come under the scope of Article 828 of the Rome Statute, under which the transfer, direct or indirect, by the occupying power of parts of its population into the territory that it occupies could be considered a war crime. This article of the Rome Statute goes beyond Article 49 of the Geneva Convention, since it targets not only direct but also indirect transfers. However, it is more restrictive since it demands a determined plan and policy. However, we can see that even if the court, in its advisory opinion, doesn't go into the nature of war crimes, and it wouldn't have been able to do this, to mention the Rome Treaty in 2004, it does nevertheless say, and I quote, that since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the occupied Palestinian territory, contrary to the provisions of Article 49 of the Fourth Geneva Convention. And it stipulates that this convention prohibits not only forced transfers, but also all measures that an occupying power could take to organize and to promote transfers of parts of its population into an occupied territory, rather, part of its civilian population into an occupied territory. This takes us back to a discussion we had in The Hague on whether we were talking about transfers by coach or whether it had to be forced transfers for it to be under the scope of Article 49 and of war crimes. But no, in fact, any transfer or direct or indirect implantation of a part of the population. So, in my view, that argument is removed. Moving now on to the notion of transfers itself, the fact-finding mission devoted 10 paragraphs of its report to describe the outlines of this plan and this policy, as well as to the government funds, the budgetary funds that were allocated to implementing these plans. This was fairly easily done because this policy is ongoing and it's indeed discussed openly. We can see on the television when Netanyahu announces on the news that 300 new houses are being planned either in the West Bank or in East Jerusalem. The mission produced a map of settlements and concluded that they formed a tight mesh, a tight net that constituted creeping annexation, making it increasingly difficult and further complicating territorial continuity, which would allow Palestine to have a state with a viable territory. As we said yesterday, the mission also noted that this policy seriously sabotaged the Palestinian people's enjoyment of the right to self-determination. I'm not going to go back to the discussion in The Hague. I'll just recall it for those who weren't there, namely that war crimes, and these are war crimes, even if they are constituted considered in the sense of Article 8 of the Rome Statute, must, in order to be prosecuted, meet rather complex criteria, such as accountability, because in the ICC, we're not talking about the accountability of states, but rather individuals. And so there is a need to target frontline, active individuals. And it has to be active so that we're not going too far back in time and we fall outside the scope of the convention. And so there is this difficulty of targeting precisely the right people. There was an obstacle, which I believe has been overcome, and that is establishing the severity of the facts in question. The prosecutor in The Hague, and she comes from Africa where there are vast numbers of massacres, and she considered that the severity had to be of a great amplitude, and yet in the flotilla case, you remember the case that the flotilla that attempted to dock in Marmara in Gaza, there were 4 deaths, and she considered that 4 deaths was not sufficient. She made a decision saying that she did not want to launch an inquiry. There was an appeal before the court, and the court handed down an extremely interesting decision. It went back on this, saying that severity wasn't a question precisely of that. The crime, rather, had to be considered on its own merits and not on the basis of the number of victims. And on this, they analyzed all of the conditions under which these persons were picked up and detained. And I think that this decision on severity will perhaps make the prosecutor think again if she is perhaps tempted to think that a situation is not characterized by mass numbers of people dead or disappeared. There could still be severity. This is rather related to the phenomenon, to a systematic policy, and so there is no need to form a ranking between different war crimes. That was not what the convention had in mind. And severity here doesn't relate to the relation with other more serious crimes. It's rather related to whether things were done or were not done. Now, that doesn't resolve all the problems, as we said at The Hague. There's still this notion that worries me, that of the interests of justice, which is extremely subjective and which lends itself to a number of somewhat dubious interpretations, because you could include many things under that, and it could involve external pressures that cannot be entirely ruled out. Now, let's look at the impact of settlements or colonies on the rights of Palestinians and then on the recommendations that the Commission delivered, in particular as regards states' responsibility. The right to self-determination is not the only one that is compromised by the current situation. Yesterday, we discussed the establishment of a drastic military grid system which engenders flagrant discriminations. These multiple checkpoints, daily detours that are made necessary, which hamper mobility, all of these undermine the freedom of movement. I don't think we've sufficiently stressed the issue of land confiscations, land seizures, and demolitions of houses. This is covered under Article 8.4 of the Rome Statute. Demolitions of houses are only allowed for the construction of military zones, but if the military zone is simply a pretext, then here, if the prosecutor sees that a military zone is being declared and then the following day this zone is maybe 8 days later is handed over to settlers, and we've seen that in some cases, that's fraud. It's not a military zone. That military zone is a pretext. Then I think that could come under the scope of another aspect of war crimes, the demolition of houses, because in these cases the military zone would only be a smokescreen. On the subject of settler violence, we considered this yesterday. The Israeli government is not prosecuting these crimes. Or rather, it is now engaging in prosecutions, but these are only cosmetic prosecutions designed for the benefit of the international community. Settlers enjoy all of the civil, political, social, economic, and cultural rights that are denied Palestinians, including the right to water. And Palestinian landowners, property owners, as was mentioned earlier, are subject to a complex civil law. They have to prove their ownership by titles, by deeds that were issued under the Ottoman Empire, then the British Mandate, and then the Jordanian occupation. This is a real headache and a Kafkaesque procedure. And of course, it's discriminatory because it is not the case for others. Now, the criminal regime that applies for settlers is the one that applies in Israel, so it's covered by the covenant, whereas the one for Palestinians is military. It involves arbitrary arrests and detentions. No fair trial is guaranteed them, and children aged 12 to 17 serve their sentences in Israel. So they don't have a special regime for minors. They serve their sentence in Israel, which is contrary to Article 76 of the Geneva Convention, the Fourth Geneva Convention. So once again, this is a violation of humanitarian law. If it's not a human rights violation, it's a humanitarian law violation. We have the very existence of the settlements, which is a violation of humanitarian law, and then all the consequences of it, which are violations of human rights and also violations of specific provisions of humanitarian law. Now, when I said earlier that I would come back to speak about states, and in a document, a General Assembly document that you all have access to in all the languages, the mission made a number of conclusions and recommendations. Well, recommendations for Israel, they're the same as the recommendations of the Secretary General, namely putting an end to colonization. But what is slightly new is that we asked states to assume their responsibilities. We asked, first of all, private enterprises to do this, but since we don't have an influence on private enterprises, that's not so achievable. But for states, we ask them to stand up to their responsibilities, to apply the 2002 General Assembly resolution, which gives a third state guidelines of how to act in its relations with a state that violates provisions of international law. Indeed, it violates peremptory norms of international law. States were encouraged to do this for themselves, but also for state enterprises, or those that were controlled by the state, with activities in settlements. There was a provision which may seem somewhat strange to you, but a final provision which meant that the report was almost not accepted by the European group. They were very hostile to this, namely considering handing this issue over to the Council Working Group on Business and Human Rights, suggesting that this working group be seized of this issue. That caused a lot of hostility, but nevertheless, it was ultimately accepted, and for a very simple reason. That's because they decided not to apply it. So, as Ambassador Mansour said to me yesterday, regardless of everything taking place before the ICC, this can take a long time, and so if there is something to be done, it's really up to states to do it and to take the responsibility to urge private enterprises, as was the case for Orange in France, to identify what is being done in Israel alone and what is being done in the settlements in terms of business activities. It may be a bit difficult for massive companies, but there are some manufactured products that for which this can be very easily done. When we were in Amman, we had a list of all of the products that were manufactured in the OPT, and so it's quite simple to identify these products. So for that reason, I think it is important to continue persevering on this to make colonization difficult, if not impossible. So thank you, and I apologize for having interrupted my statement slightly. Thank you for the tea.